Tātou mā kua tukuna mai ki au te honore ki te whakapuari tō tātou noho ki te inui. Nā reira ki a inui tātou. Kia tātatanu mai koe kia mātou i hoa i roto i tēnei hononga ki te purangi mo te roa ngāke o tēnei rā. Manākiti ana koe ngā roia ko hono mai kia māra mai o a rātou haka ātūranga ki mua i te aroaro te tēpu i te rānei. Manākiti anō ki koe a mātou hoki o te tēpu kia tae te hopu i ngā kōrero ki te aka tutu ki ngā kia tae te tātari i ngā kupu me te kia tutu ki pai ei te kaupapa tae no ki te mutunga tēnei hononga i te rānei. Haka tautunu koe o manākitanga ki runga i tā mātou kai whakawā hoki wāra ki te hakatutuki ngā mahi i mua i aia, hei paingana mau, hei paingana mō mātou katoa whai pāngāna ki tēnei kaupapa. Ko te inu ki tēnei ki au kai pāmau nei whakamana mai, i runga nei te ngua tāutama te kai whakora ko i kuraiti. Āmene. Kia ora tātou.
Ko te mea tōtahi tēnei au mihi ana ki a koe matua Kevin i tō karakia kia whakawahi ai tēnei nohoanga. Kia koutou katoa nau mai hara mai ki tēnei nohoanga o te ropu whakamana i te tiriti. Ko te kaupapa o te rā ko ngā kirimi Waitangi Omua. Ko tēnei tō ropu hou. Ki taku taha mātau, ko Kingi Kiriona tēnei, no Ngāti Ruanui, ngā Rauru, ko Ngāti Kahungungu hoki. Ki tōna taha, ko Rex Hale, no Ngāti Parau. Ki Harataunga, ki Mataora, no te Rarawa hoki. Ki taha takutaha Māui, ko Takuta Paul Hamer, ko ia te tumu kōrero i te kaupapa nei, kei konei ia ki te āwhina i a mātou, o i a tātou, o te kaupapa. Ki tōna taha, ko matua Kevin Prime no ngā puhi ia. So, nō reira, tēnā koutou. Thank you for, ko waio, ko te kai whakawā wara ahau, no Waikato, no Ngāti Raukua ki te tonga hoki. So this is our the first judicial conference that's been convened for our new rōpū. As you know, the kaupapa for this judicial conference, Y2800, is an inquiry into the remaining historical claims. And just for brevity, a historical claim is a claim that was filed with the Waitangi Tribunal on or before the 1st of September 2008. And it pertains to an action or omission of the Crown that occurred before the 21st of September 1992. So those are the primary parameters that we're dealing with in terms of historical claims. But I will hand it over to counsel for appearances, or counsel and claimants for appearances. Kia ora.
Pēnā koe, Judge Wata, ko Janet Mason tako ingoa. I appear for two claims. The first one is Y2147, and that is a claim by Moirangi Potiki, Willie Tapsell and Liam Tapsell on behalf of Te Runanga o Ngāti Whakawe, and they're located in Maketu. The other claim is Y1940, and the claimant is Ms. Jane Mihirangi Ruka Te Korako, and she is the chair of the Grandmother Council of the Waitaha Nation, and those are the two claims. Tēnā koe, thank you.
Tēnā koe.
Pēnā koe te kai whakawā, me te rōpū I te tiriti o Waitangi. May it please the Tribunal Council's name is Gilling, and I appear this morning with other members of the Māni Hōna Rōpū, Ms. Fellows and Ms. Tuliafua. We appear this morning on behalf of 3 claims: Y158, Robert Kenneth McInerney, and that is a Silner claim. Y994, Gertrude and Donald Horns, that is also a Silner claim. And Y2543, Doug Huria, and that is a claim on behalf of Ngāti Tūmata Kōkiri, which is an iwi located in the Maruia through to Tasman Bay region. Ma'am, I also wish to advise that we have contact with 2 other claims that we are trying to see where they're up to. Y685, claimed by Edward Palmer. Now, we know that Mr. Palmer is deceased, but the trust that he was involved with, again, it's a Silner claim from down in the Catlins. We are trying to ascertain where they are going with the claim, if at all. The other one, again, it's a Silner claim, Y783, and the main claimant for that is Professor Hirini Mutunga. And again, we're trying to make contact with Professor Mutunga. Thank you, ma'am.
Thank you, tēnā koe, Dr. Gilling.
E te kai whakawā, me te rōpū whakamana I te tiriti o Waitangi tēnā koutou. E ngā hoa mā, e te kraina, me ngā kai kereme e tūtakitaki mai nei tēnā koutou. E te kai whakawā ko Neiran tōku ingoa, kei ko nei hoki a Mr. Fletcher, e toru ngā kereme I mauria mai, ko te kereme tuatahi Y2460, ko ngā kai kereme ko Anthony Olsen, Trudy Olsen, and Catherine Olsen, mō nā uri o Waitaha ki te Waipaunamu. Ko te kereme tuarua, mō Ngāti Taimana o Iti o Tāmaki Makaurau, ko te kai kereme Jasmine Cotter Williams. He kereme anō ko MIR 6215. He kereme no Anne Te Maiharoa Dodds, Kelly Te Maiharoa, Angi Te Maiharoa Kua Mate Ke, mō te iwi o Waitaha, me te taiwhenua o Waitaki Trust Board. E kereme anō Y1553, ko ngā kaitono Silvana Wirepa, rāua ko Suzanne Jackson. No te pānau apa nui, e nei kai kereme, ko Panarua Bay te rohe, te wāhi o te kereme nei. Kua uti tēnei kōrero a tēnā koutou.
Tēnā koe, Mr. Naden. Kia ora.
Tēnā koe te kai whakawā, anō hoki kia koutou nā me mō te rōpū whakamana te tiriti o Waitangi. Tēnā koutou. Ko Lyle te poingoa, ka tū nei a hau mō Y111, te Rāpo Lands Claim. Good morning, Your Honour. Lyle for Y111.
Good morning, Mr. Lyle.
Tēnā koe te kai whakawā, tira te tiriti o Waitangi. Y1006 he kiremina Florence Karitiana mo Ngāti Kurapoto. Tēnei te mihi mahana ki a koutou.
Tēnā koe.
Tēnā koe te kaiwhakawā, hoi rongo hau, he roira mō by 2236, a claim for Irina Clark. And Mum, just while I've thought of appearances, I actually represent Y2324, which is a claim for Neil Jury on behalf of the Geary whānau. Now, on 16 November 2022, we actually filed a memo withdrawing that claim. So I just wanted to make sure that the tribunal's records were up to date with that. It was originally included as part of this inquiry. Kia ora, Mum.
Kia ora, Ms. Rongo.
Tēnā koe, Mum. Me tō rōpū e whakamana te tiriti, he mihi tēnei ki a koutou. Simply here, Mum, I'm at the moment seeking instructions from claimants that are yet unheard. I do not have instructions at the moment, Mum. Thank you.
Kia ora, Mr. Sinclair.
Tēnā koe, Your Honour. May it please the Tribunal, Counsel's name is Hewitt from Woodward Law. I'm here on behalf of one claim, Y1623, Ngāti Rangatahi.
Tēnā koe, Mr. Hewitt. And do we have Ms. Megan Brady-Clark online? Cool. And do we have Tui Marino online?
Ai, hei konei hau.
Tēnā koe. Tēnā koe, Mr. Marino.
Tēnā koe tō. Me kōrero.
Ai.
Tēnā koutou katoa. These are 10 claims. Y390 was originally a claim by the late Hone Tau Maunu for the Runanga o Paikia. But then I was added on to as the claimant, and I made amendments, and the claim is now on behalf of the shareholders of Hawiti Corporations and Mangahea 2D Incorporations, based on that they were or are descendants of the original hapu occupants of those whenua. The second claim is Y976, that was filed in 2002. That's a generic claim on behalf of hapu of Te Aitanga Hawiti. The third claim is Y1331. It's a hapu claim in relation to the hapu within the Tolaga Bay area, and there are over 32 hapu in that area. Y1303 is the southern area of Te Aitanga Hawiti. Rākai a tāne te hapu. Ngāti Oni te hapu is the name of today. The fifth claim, is 1566, Soldiers Settlement Claim, originally filed by the late Tautini Glover, and myself, Ron Baker, are the only living claimants of that today. The sixth claim is Y1266 by Rutene Kokiri, originally filed forward on behalf of Te Umu o Te Oha Kapi. The seventh claim is Y1249 by Mahora Edwards on behalf of Ngāti Korohi, hapu of Te Aitanga Hauiti. The eighth claim is Y1302 by Tony and Carl Naden on behalf of Te Whānau Te Ao Tāwarirangi and Te Whānau Rua Taupare Hapu of Tokomaru Akau. The ninth claim is Y703, Taupare Pārai blocks, and there were three claimant iwi within that shared claim. That is Te Aitanga Hauiti, Te Aitanga Mahaki, and Ngāti Iro. And the last claim is Y646, for and on behalf of a Rangiuia claim in relation to Rua Peka Peka Te Whare Whakairo that is currently sitting in Auckland Museum. And that was by Charlene Marino, she's my cousin. So those are our claims, Your Honour. Tēnā koutou.
Tēnā koe, Mr. Marino. And I see that we also have Mr. Melvin online for the Crown.
Tēnā koe te kaiwhakawā, tēnā koutou ngā mema o te rōpū whakamana I te tiriti o Waitangi, tēnā tātou. Yes, Your Honour, Melvin for the Crown.
Tēnā koe. Now, have I missed anyone?
Kia ora, Judge Wara, ko Wilson tōku ingoa. I'm appearing on my own account. I don't actually have any status as a claimant yet. I'm standing for a claim way 187. So my parents are Arnold Manaki Wilson and Tinia Wilson, or Rangi Tinia Wilson. They're now deceased, and I want to join as a claimant. I've tried to contact the current living claimant in area Woodward. Not successful yet, but an ongoing process for that. I'm just wondering if you could recognise me for this hearing.
Kia ora, Mr. Wilson. So look, the agenda for our judicial conference today is relatively brief. Effectively, we're really looking to provide an introduction into this new inquiry process and talk about the implementation. And then finally, this is really a question and answers opportunity for counsel and claimant to get some clarification about the process as we move forward. So in terms of Y2800, perhaps it's helpful just to do a little bit of background into the claim because I know some of you, such as Dr. Gilling, have had previous involvement in this process. But in terms of where we started, back in 2015, the then chairperson of the tribunal recognised that there was a need to address those historical claims that had fallen perhaps outside of the district inquiry process. And so a process commenced at that time, and initially in 2015, the focus of the inquiry was eligibility. And after approximately 500 historical claims were identified, it was then assessed that perhaps eligibility was not going to be the best approach. And ultimately, it led to a regional approach for dealing with these remaining historical claims. That commenced in 2018, and a region what's been referred to as Region 1 had started. And when that first region was put together, there were approximately 72 claims that fell within that regional approach. But as matters progressed, the number of claims dramatically declined. Now, I've come on board as the presiding officer for this inquiry. I was appointed a couple of years ago, and effectively some work has been done behind the scenes to assess what are the outstanding historical claims that could potentially be heard as part of this inquiry. Rather than starting from an approach of eligibility, I want to hear from the claimants who wants to be part of this inquiry, and if so, what's the nature of the resources that's going to be required to get your claim to hearing. But I guess before we move into determining who's going to be heard, we will need to make a call on whether we have jurisdiction to inquire into your claim from the outset. So you'll see that a memorandum was released at the beginning of this year, the 12th of January. So that memorandum of directions set out the new approach that we're going to be undertaking as part of this process moving forward. So we're going to be dealing with matters differently. As you will all appreciate, the Waitangi Tribunal is under pressure in terms of resourcing, but also since the effects of COVID-19, we've taken different approaches to the use of technology to be able to hear claims. The nature of this inquiry is that we want to hear, we need to undertake an assessment, firstly, as to who wants to participate. And as you will know, a notification or pānui process commenced. That commenced in January and is to continue until the 11th of May. And all claimants who wish to participate in the remaining historical claims process need to notify the tribunal by the 11th of May. That's gone out in the pānui, it's been notified. Any claimant that doesn't notify within that time frame will not be heard moving forward, and for that reason we're undertaking an extensive pānui process at this time. So that's the first critical date in terms of progressing matters. We've also tentatively fixtured a further judicial conference on the 22nd of May, and that's for further inquiry planning. So as you'll appreciate from the memorandum of directions, effectively, historical claims has been given priority in terms of the inquiry. So the intention is for this inquiry to wrap up, for reports to be delivered by December 2030. So in between now and December 2030, there's a lot of work to be done. And I guess I'll move now on to talking about the new approach. Just a slight overview as to the historic claims. At this time, there is a count of approximately 1,700 claims that could fall within the purview of this inquiry. And really, what we want to know is, of those 1,700 claims, who wants to participate? That's the starting point. Once we have received clear indications from claimants and counsel of participation, I want to hear from counsel as to where you think the claim that you represent falls into. So we have constructed 3 categories. Firstly, category 1. So that's the historical claims where claimants no longer intend the tribunal to inquire into, or historical claims that are ineligible because they've been fully settled or previously reported on, or because they're subject to treaty settlement. So category 1 is the claims that will be put to the side so that this tribunal can then focus on category 2 and category 3 claims. Category 2 claims comprise of claims where claimants are ready to be heard, and we will give priority to those claimants that are ready to go. So this is a claim where there is no gap-filling research required, where potentially the claim can be inquired into on the papers with consent of the parties, or where the claim can be inquired through the use of remote technology. For instance, we convene a claim-specific hearing and bring the panel in using AVL for a brief hearing. So that's a Category 2 claim, and that will be given priority. Category 3 claims comprise of claims which are somewhat more complex because further research is required, or there are issues as to overlapping interests, and we will need to bring those affected claims together, and perhaps there's a need for a more extensive hearing. So that's the notion of categorisation. We recognise that this process, there is a fluidity to this process at the moment. The reality is we don't know what we're looking at in terms of claimants wishing to participate, and we will not have a clear view on that until the 11th of May, or after the 11th of May, when the pānui process has ended. So that's the issue around the claims at the moment. One matter that I do want to highlight is that if your claim is in relation to a nationally significant issue which falls within the scope of a kaupapa inquiry, then that claim will generally be heard within the given kaupapa inquiry. This process really is for those claims that have fallen through the gaps. Ka pai? So I guess that's my little overview as to the background of Waitu 800 and the approach that we intend to implement. And I'm happy to receive questions or have a discussion.
Tēnā koe, Mum. I was just wondering if you were open to releasing some of the claims that look to fall within this inquiry so that Claimant Council can assist in reaching out and connecting with the community that we're involved in, and perhaps bringing more people to realisation of what's occurring.
Yes, thank you for raising that, Ms. Rongo. We will be putting up a document on our website shortly, which lists the outstanding historical claims. That list will include the named claimants and the area or the issues for which the claim relates to. So that will be available on our website very shortly.
Tēnā koe, Ma'am. Gilling here. I've got two questions which you may not be able to answer yet. And I guess they both depend very much on what happens, what's come forward by May. Both of them are about the availability of resourcing. Now, the Category 3 claims still need resourcing for for research. We've been told that in Te Waiponamu, there is no CFRT funding available, for example, because everybody's been settled, all the forests are gone, etc., etc. So all of our SILNIC claims have no resourcing available. We've managed to secure a little private or separate funding to progress things. So our ability to proceed to hearing is dependent on getting some additional resourcing for that research. And the other question is also, you have indicated that there will be some hearing time available for activity next year, and you have also indicated the priority given to the Category 2 people. But I was wondering if you have any further indication of just how much hearing availability there might be next year.
Thank you for your questions, Dr. Gilling. Look, on the first issue around the resourcing, I can't give you an answer about that issue now. I have had a discussion with our research team, and the intention is once we know the full scope of claims that are wishing to participate in the inquiry, then assistance will be provided to point claimants towards existing research that's already been undertaken. But also we will then be in a position to look at the gap-filling research that's required for those claims that fit within Category 3 and how that could be resourced. So we'll be looking at that, Dr. Gilling, but that we'll be looking at that a bit later this year. Not too late, but a bit later. And I've just received a note just in terms of Ms. Rungel's question around the claims. The list of claims that's going to be put up on the website will include all claims received by the Tribunal by the 1st of September 2008. So it will include claims beyond just the outstanding historical claims. So hopefully that provides some assistance to counsel who are looking to help claimants.
Ai te kaipakawa, Mr. Naden. Ma'am, so there was a phrase you used in Category 1, subject to treaty settlement. The whānau apanui settlement negotiations have been happening for some time. I understand there's been a stalling of those negotiations, Your Honour, over a particular sovereignty clause in the settlement legislation that the Crown's uncomfortable with. And so whānau apanui claimants who had their claims deferred from the North East Bay of Plenty inquiry are not yet settled, technically, Your Honour. That settlement negotiation process is it's not clear whether it will lead to a treaty settlement. One of the claims I referred to earlier in appearances is a whānau apanui claim, and flagging the situation to Your Honour and whether that claim is included in the phrase subject to treaty settlement.
When we get to the point of determining jurisdiction, Mr. Naden, you'll be invited to provide submissions at that point as to why jurisdiction continues to exist for us to hear into those claims.
Yes, thank you, Mama. That was my next question, and you've wrapped it up in with one hit. Ma'am, moving to what Mr. Gilling raised in relation to resourcing, and after a series of tussles with the Ministry of Justice and the Legal Aid Service, the position seems to be that if the Waitangi Tribunal sees utility, does not necessarily have to support proposed research, but sees utility in that research and states so much, say in a memorandum direction, then Legal Aid Services is more inclined to grant the funding that's sought for that research, Your Honour. And Mum, when I say tussling lately, this is my understanding from recent correspondence with Legal Aid Services, a Legal Aid Tribunal decision, Your Honour. So hopefully what I'm relaying to you is accurate. But that can be said to be the position for quite some time now. In this submission, Your Honour, that if a tribunal judge sees utility, there's an inclination to support the research sought and the funding of it, Your Honour. Unless there are questions, ma'am, those are council's submissions.
Thank you, Mr. Naden. That's helpful information, and I am happy to work alongside council in terms of these issues with research and phrasing things in whichever way is required that will assist in obtaining funding through other areas such as legal aid. So if sees utility is the key phrase, then I am happy to use that phrase, Mr. Naden.
Thank you, ma'am.
Tēnā koe, Your Honour. It's Ms. Mason here. I know that the Tribunal has set out the 3 categories and is prioritising Category 2. I filed a memorandum yesterday, in relation to the Maketu claimants, Y2147. They have just about to start a group that involves their claims are about to start treaty settlement negotiations. So they have respectfully sought priority on the basis that if the settlement process is successful, then their claim will be extinguished, and that might not be something that they would like, or the jurisdiction of the tribunal will be removed. So I wondered if there was a possibility that the tribunal could look at some special category, such as those claims that are on the verge of treaty settlement negotiations that may want to have an inquiry earlier.
Wouldn't that fall within the scope of urgency?
So, sorry, Your Honour, so are you saying that one option is for people in this situation to seek an urgent inquiry?
Well,
Well,
I guess for me, the primary issue, the question is the claim ready to be heard? Is there a need for research, or is the claim ready to be heard? Because if there is a need for research, we simply are not in a research phase, and we don't have the resourcing immediately to be able to assist. So for that reason, that's why priority will be given to those claims that are in Category 2, who are simply ready to go.
Right, so, they would be able to have their research done within 6 months. So that is a possibility, because it isn't extensive research that's required. They have some research already, but they do need to undertake more research.
And when you say they need to undertake more research, are you asking the tribunal to assist with that research, or is it that your claimants are undertaking their research and they'll be ready for hearing shortly?
They would be going to legal aid for some of it,
yes.
But some research has already been done.
Okay.
So the gap-filling research would take approximately 6 months.
Okay.
I'd say.
No, thank you for bringing that to my attention. And look, we will, as I've signalled, we haven't categorised claims at this time. We'll be working through that process once we've received all the claims, and we will take into account those claimants that are signalled that they're ready to go in terms of how we manage the hearing process in 2027.
Thank you. Thank you, Your Honour.
Tēnā koe, Your Honour. Lyle here. The claimants that I have instructions for are the whenua was within the inquiry district for the Northland inquiry, but at the time those hearings were taking place, there was no living named claimant. So it's a recent development that they've had hui and reactivated the claim. Really, I was seeking guidance from the tribunal about whether the appropriate course there is to seek a further discrete hearing from the panel that had carriage of that area, or whether those are claims that this panel is planning on looking at. I've filed a memorandum in the Northland inquiry some years ago and not been able to have a response on that. So I'm exploring the options that I have available to make sure that this claim does get heard. And if it's here, ka pai, or if it's in the Northland inquiry, then we're happy to progress it there. As far as the category goes, we've applied for legal aid and won't really be in a position to review the file and make that assessment until that's granted. But that I wouldn't have any issue with meeting the timetable that you've talked about.
Ka pai. No, thank you for raising that. Look, I'm certainly not going to give any indications today, Mr. Lyle, as to how we'll deal with that issue, but fundamentally, once we get past the 11th of May, we will then be working more closely with the claims and what needs to take place with those claims, and what the jurisdictional issues are with those claims. And so we will deal with that issue in due course.
Thank you. I'm aware, I don't have instructions from them, but I am aware that there's a number of Northland claimants in a similar position. So I think it's going to be a common matter to confront.
Kia ora. Do we have any other pātai?
I'm Killing here again. Thank you for your answer about the research, and of course that's been fleshed out a little more in your subsequent discussions with my friends. You didn't, however, answer the question, if you're able to, about the hearing time that might be available, in the more or less near future.
To be honest, Mr. Gilling, we're not clear as to the extent of hearing time, and how we're going to manage the hearing time. So, for instance, if the issue is discrete and we can deal with it in half a day, then remote technology is the best way of dealing with that, then that will be a relatively simple process. It becomes more complex where there's issues that overlap, and hearing time in person is required, and the length of that hearing time is greater than a day or two. So until we have a better view on the claims, I can't answer you as to the extent of hearing time that's available, but we will certainly be looking at working with claimants and counsel for the most efficient and best use of all of our time. The reality is we have been provided with priority to hearing these claims between 2027 and 2029, and I expect to be resourced properly so that we can properly hear into and inquire all these historical claims.
Tēnā pai. Kia ora, Mum.
Do we have any other questions? Does the panel have any questions or anything that you'd like to add? Carl, okay. Well, we don't have any questions or anything further from the panel. So it's tribunal as to what's being sought. What are the recommendations that are being sought? I anticipate that the historic claims that are going to fall within this inquiry are for discrete issues. This is not a generic issues inquiry. That this is an inquiry where there's historical issues that have been missed, historical issues in council as to what recommendations are being sought from us to for the time when we report on the claim. And unlike inquiry districts where there's been a generic approach to dealing with the claims, I anticipate that this is more of a claim-specific approach. And we'll be treating it as such. But that in terms of being able to meet our timeframes of getting everything heard in a expedited process, I'm going to need as much help and assistance from council as possible to be very clear about the grievances, the information that you have, and the recommendations that are being sought.
Thank you, Your Honour. Just to butt in at the risk of dragging things out, something that's been very helpful in the inquiries where no CFRT funding has been available is the Crown providing funding for claimants to attend and to bring support people and to have some preparatory hui, things like that. It's not something that I'm expecting my friend Mr. Melvin to be able to respond on now, but normally the relevant government department or ministry is the contact point depending on the nature of the claim. And here there's no obvious department apart from perhaps Te Ture Whakatau. So wondering if the Crown has an update on whether any planning's taking place for that or if that could be put on the work stream for them, because if things are going to be held online, that's one thing, but if we're going to be coming together for an in-person hearing, then getting people there and getting support people there is really important on the day.
Shall I respond to that, Your Honour?
Yes, please, Mr. Melvin.
So claimant funding for this inquiry is an issue that officials are giving consideration to. At this stage, there isn't a firm policy in place for the Y2800 inquiry. But Council should be able to give an update at the next judicial conference as to that matter.
Thank you.
And Your Honour, I just I had a question arising from your comments that you were making last, just in terms of reporting. Is the tribunal anticipating reporting as it hears matters, or is it anticipating reporting all at once in one report at the conclusion of the inquiry?
Mr. Melvin, we haven't really determined that, but I do think that it would be helpful, like, once we know exactly what we're dealing with, and if there are discrete issues that can be dealt with quite simply in 10 pages or less, then I would anticipate then you would get a report sooner rather than later. So fundamentally, it depends on the complexity of the issues that come before us. If they are matters that can be dealt with quite simply, then I can't see any reason why that a report cannot be released sooner than 2029 if we're hearing the matter in 2027. But as I said, I think fluidity and flexibility are going to be the key drivers of this inquiry so that we can make it to the finish line.
Thank you, Your Honour. That's a helpful indication.
Okay, well, look, if we don't have anything further, then we can bring our judicial conference to an end. Matua Kevin, e whakakapi te karakia.
Kei nei tātou. E pae tō mātou matunui te rangi. E tuko tino mātou tēnei reo whakawhita e whakamoimiti ki a koe pāmunga tini mena akitanga. Ko uhia mai e koe ki rungi a mātou I roto I tēnei hui huinga. Mai te timatanga I te ata nei taino ki tēnei haora hakamutunga. Tō te ina te ki a koe ai nei pā ki mana ki tiana koe tēnei o mātou. E wehe tukini o mātou mahi, wehe tukini o mātou kāinga. Wai hotunu e te hātau wairo tapu ki runga ngā āpia ki te whakatutuki ngā mahi I mui a rātou ke puta, ke ne pai ngā runga tiwi e whai pāngāne ki tēnei kaupapa. Ko te ino ki tēnei ki a koe pāmau ne whakamana mai, I runga ne te ngua tāu tāma te kai whakora koe I karaiti. Āmene.
Āmene. Kia ora.